laude at University of Natal and an LLM from Cambridge. Is that right?
Indeed, it is so.
Yes, and yet you were admitted as an attorney in 1988. Is that right?
Correct.
And you practiced for about 7 years or so. Then you were appointed as a judge at a very young age, namely at 35.
That's correct. I think I practiced for 10 years.
Oh, it was 10 years. Yes. And then you were appointed as a judge of the Land Claims Court at age 35.
That's correct.
That was quite young.
It was very young. I think it was only, Justice Strawberry that might have been a year or so younger than me when he was appointed, but I was one of the youngest to be appointed at the time.
Yeah. Yes. And then your appointment was for a period of 5 years, which would go up to 2000. Is that right?
Indeed.
And you served all that period of 5 years. And during that period, you wrote a number of judgments that got reported. Is that correct?
Indeed. They're listed at the end of my curriculum vitae.
Yes. And you were one of the first Land Claims Court judges.
Indeed.
And therefore, that must mean that when you started with your colleagues, you were really starting on something new. The jurisprudence was not there. You had to start a new field of law.
Indeed, we started with a completely clean slate, and a set of statutes. Initially, the Restitution Act. Later, other statutes were added to our jurisdiction, and we had to develop the law from there. But obviously, guided by the Constitution, which was already in place. Initially, the interim Constitution, and then subsequently the final Constitution.
Just take 1 minute to share with the commissioners how that experience was of starting a new court and a new jurisprudence on land law in a democratic South Africa.
With pleasure, Acting Chief Justice. It was obviously a unique experience. There was a substantive dimension to it, and there was obviously a procedural dimension to it. The substantive component involved interpreting the legislation. As the Constitutional Court ruled, a judgment of Deputy Chief Justice Moseneke in the Goedgelegen judgment, the land reform legislation is umbilically linked to the Constitution. So in a sense, it was really constitutional adjudication that we were busy with from the outset, and we did have the guidance that was provided by the Constitution for purposes of that from a substantive point of view. There was limited foreign authority that could be referenced, but I had a background in both human rights and specifically in dealing with forced removals, and I think that gave me the framework within which to act substantively. It was a great honor and privilege to write judgments. From a procedural point of view, we had to start from scratch. We had to find a building, we had to draft rules, we had to establish a library, we had to establish an IT infrastructure.
Yes.
We received enormous help from the Constitutional Court, but I got stuck in with all of that stuff. We worked well as a team, and we eventually had a thriving court, which is still there today.
Thank you. And during that term of 5 years, you wrote quite a number of reported judgments. Is that correct?
That's correct.
Do you have an idea about how many? I know we've got them in the pack here, about how many reported judgments you ultimately wrote, more or less?
I didn't count them. My guess is about 25, but I might be wrong there.
And when you were appointed as a judge of the Land Claims Court, had you always planned to go back to practice after the period of 5 years?
It wasn't always my plan. I had to make a decision when I got to the end of my 5-year term as to what I would do. And it was only, I suppose, in the last year that I began to crystallize my thoughts. There was also the difficulty that we didn't know what was going to happen. We had to wait to see what the government had in plan for us.
Yes. And then after that period, you went back to practice, and then you didn't go back to practice as an attorney. You went to the bar. Is that right?
That's correct, Acting Chief Justice.
Yes. And you are still at the bar. You took silk about 10 years ago?
I think it was 2011. So yes, 10 years ago.
Yes. And you say that the cases that you dealt with were very much constitutional law based.
Well, perhaps I should mention, before I get to that, the period from 2000 until 2007, although I was at the bar, I think the major focus of my time was an appointment that I had to chair the Housing and Property Claims Commission, which was a body established by the United Nations in Kosovo to deal with the aftermath of the war, and in particular, property claims arising from the war. They took up a substantial part of my time for the first 7 years at the bar. But I did some bar work during that time as well, and yes, I went and looked back at my reported judgments while I was at the bar, and in fact, every single one of them, perhaps bar one, involved constitutional issues. The one that didn't is the case of Absa Bank and Lombard, which was a case about banking law. But in that case too, in the Supreme Court of Appeal, I argue that the common law should be developed in relation to when funds are stolen through an electronic transaction from a bank. So in a way that also involved the Constitution.
Yes, and many of the cases in which you have argued in the Constitutional Court, is that correct?
Yes, I have argued a number in the Constitutional Court.
And is constitutional law quite a large portion of your practice?
It's the bulk of my practice.
Yes, and you haven't acted in the Constitutional Court, is that correct?
I haven't acted in the Constitutional Court. There was a recommendation from the BLA in response to my first nomination in 2019, I think it was. They recommended that I be given an opportunity to act in the Constitutional Court, but it was never acted on.
Yes. In the cases that you have dealt with when you were a judge in the Land Claims Court, or when you have acted in the High Court, because you have acted in the High Court as well, have you dealt with cases where you have got to declare legislation unconstitutional and grant appropriate orders? I haven't
ever had a case where I have declared legislation to be unconstitutional, if I remember correctly. The closest I've come is to develop the common law in terms of Section 173 of the Constitution, and that was in the case of Picard versus Stan.
But you know what the approach is when you are required to declare a legislation unconstitutional. Is that correct?
Indeed, and obviously I've had a number of my cases as an advocate have involved declarations of invalidity.
Yes, and you have dealt with cases whether when you argued them or when you were sitting as an acting judge, where you had to deal with reading in and reading down.
Indeed.
Are you able to just share quickly with the commissioners what this distinction is between reading down and reading in?
Well, reading in would be the situation where, in order to correct legislation, to render it constitutional, you would have to read in certain words, and it would typically follow on a declaration of unconstitutionality in the legislation as it stood. And then reading down would be an interpretation, for example, based on the Hyundai judgment, where one aims to, through a process of interpretation, read the legislation as being constitutional in accordance with Hyundai.
Yes, thank you. Minister, do you have any questions?
Yes, DCJ, thank you. Advocate, firstly, is also to state that Advocate also help us with our Justice Reference Group on land matters. But anyway, I think that goes also with many advocates. They represent the state through the state attorney. My first question relates to a matter you're involved in, the Mwelase matter, Advocate, of the creation or the innovation of the special master. Our lived experience is that it has straddled between the separation of powers, and that the special master reports to the court and has taken some of the powers of the accounting officer and that of the executive authority. So it has created a kind of a difficult also in terms of accountability as to how do they account to Parliament, the executive authority and the accounting authority with regards to the work of the special master, whether it will be the special master or it will be the accounting officer or the executive and all that. What will you be your view going forward to government? How must we handle this special situation? Because it's new to us, and I also think it's new to everyone involved in it, so that we still find a way of it working.
Thank you for that question. The Molasi case was the very first case where a special master was appointed, and I think it was inevitable that there were going to be some pathfinding problems. I haven't been substantially involved subsequent to the order of the Constitutional Court, so I don't have a deep knowledge of what the factual position has been subsequently. But I think it's important to bear in mind that it was a particularly dire case of non-compliance with legislation. Essentially, the Department of Rural Development and Land Reform had shelved legislation, which is constitutionally extraordinary and a severe constitutional wrong. So it was extreme circumstances that required a measure like the Special Master. What's important, and I haven't restudied the order before this interview, but what was important is that the interview was based on, I would submit, a combination of collaboration, guidance, and supervision, with the Special Master required to play a coordinating role between the department on the one hand and the court on the other. At the end of the day, the Special Master is required to be the eye of the court, but because of the severe problems that have arisen, in a much closer way and in a much closer collaboration with the department. My sense is that as long as there is good faith on the part of both government and the Special Master, and if I know the individuals involved on both sides to the extent that I do, I think there is that good faith. And I think that provided there is a collaborative spirit with which they approach the matter, I think the Special Master can play a fantastic role. You know, one of the frustrations that one had on the Land Claims Court is that when problems arose in the land claims sphere, amongst other institutions like the Lands Claims Commission, the problem with the court is that you sit remotely. You don't have the opportunity to go and sit down with somebody and say, how can we solve this problem together? That's the beauty of the Special Master. The Special Master is really the agent of the court, and it's providing the department with an opportunity, instead of the court preaching to it from on high, to sit down with the representative of the court and say, how can we solve these problems together? How can we help each other? That's the spirit in which it would be done. It should be done. And my sense is that will be the guide. If there's a spirit from both sides that says, how can we help each other to deal with these 10,000 claims that have been left to stagnate for, it's now 20 years, I think it is, and more for people who lodged their claims before 2001. Let's work together and collaborate. I worry that there may be a sense of turf and a feeling that turf is being invaded. I think that's wrong. I think the way to make it work is to see it as an opportunity, to see it as having the court's agent sitting potentially in your office and solving a problem together.
Yeah, my second question relates to what the Land Claims Court has entrenched in terms of the interpretation of Section 25 on restitution matters or land reform matters to mean that any compensation should be market related, which is not what Section 25(3) of the Constitution expect in terms of what should be just and equitable. Why at the initial stages of the Land Claims Court you entrenched these principles of calculating the market price on the basis of the 1975 expropriation bill instead of what the Constitution expected the court to do?
If I can...
before you answer, Mr. Dodson, may I just mention, I will try to make sure that you get a fair opportunity to respond, but may I ask you to try and not make the answers too long? So if you can exercise restraint, but at the same time, I don't want you not to feel that you have had a chance to respond properly. So go ahead.
By all means. If I can start with the correction. The Land Claims Court judgments don't apply at market value, and as the basis for compensation in isolation. They apply it as the Constitution requires them to do, and they follow the Detroit judgment of the Constitutional Court. So if you look at the judgment of myself and Judge Meer in Kumalo versus Potgieter, we firstly determined the market value of the land, and then we looked at the other factors in Section 25.3, and we reduced the market value of the land. Acting Judge Ngukai Tobi followed exactly the same approach and determined market value, then proceeded to adjust market value. He also made the point, and the judgment in Kumalo versus Potgieter was no different, that the starting point is what is just and equitable. But what Detroit from the Constitutional Court says is you start with market value because that's ascertainable and you adjust from there. What I have some difficulty with is the Supreme Court of Appeals decision, which overturned Ngukai Tobi's decision in the Msiza case. I think that is the one that fits, that judgment is the one that fits a bit closer to what you're talking about. If you look at Kumalo versus Potgieter, the landowner did not get market value. I can't remember the exact figure, but they got several R100,000 less than market value. One is forced to apply the Expropriation Act to some extent because it's sitting there in the statute book. We can't ignore that. But we applied Section 25.3 over the head of the Expropriation Act. We wouldn't have made that downward adjustment in Kumalo versus Potgieter if it wasn't for the fact that we were applying Section 25.3 with respect correctly. The reference is in my curriculum vitae for the Kumalo versus Potgieter judgment.
Thank you. Thank you, Mr. Dodson. Anyone who wishes to ask questions? Commissioner Mapisa Ngula.
Thank you very much, DCJ. And thank you very much, Advocate Dodson, for availing yourself. The question I have, it sounds very trivial. It's a very trivial matter, but very profound as well. And commendable to me that when I looked at your CV, that your previous conviction is that you refused, and it's a military criminal record, that you refused to patrol with the army in the townships. However, much as I would want to commend you for that, because I think you took a very good decision, I would want to understand, is it something that you want to keep? You don't want, why have you not applied for a nullification of this record so that it doesn't keep on popping up in your CV? That's the number one question.
I'm battling a little bit, Commissioner, to hear you.
Well, I was actually going to ask everybody because when Commissioner Nujesi was speaking earlier on, I couldn't hear him so well. And so I don't know whether you need to come closer to the mic or something else. Thank you. So maybe speak closer to the mic.
The issue is, I see that I read from your CV that one of the things you did is something which is very commendable, which is that you refused. You have a military record for refusing to patrol in the townships. However, my question is to you, is this something you want to keep? Why have you not applied for a nullification of this criminal record? That's the first question. And the second question I have is...
Maybe let him answer that first one.
Okay.
Mr. Dodson.
I don't see it as it's something I don't want to hide away. It's something I'm proud of, frankly, that I acted in accordance with my conscience, and it hasn't interfered with my professional life in any way. So from that point of view, I haven't felt a need to seek a nullification. I don't even know if there's a procedure to seek a nullification, but I'm proud of what I did.
Thank you very much, Advocate. The second one is having, but of course I think you responded to that from the issues which were raised by the DCJ earlier on, that your focus has been on land restitution. And therefore, how would you describe your abilities to decide on matters which will arise, which relate to litigation issues at the Constitutional Court?
as I understand your question, it's I come from a specialized background. How do I deal with other matters? To respond to that, let me start by saying I'm similarly proud of the fact that virtually my entire professional career has been aimed at dealing with the problem that black people were forced off their land in South Africa. And I make no apologies for the fact that that's been the focus of my professional life. But I have been widely involved beyond that. In the Land Claims Court, we inevitably, and the Acting Chief Justice I think will bear me out with this given his experience in the Labour Court and the Labour Appeal Court, specialists of course sit within the matrix of the broader legal system. Every single case just about brings out other issues from other components of the legal system. I in fact made a list which I can make available if need be. I don't want to waste time by going through it, but of both non-constitutional, non-land reform issues that came up in my reported judgments, and there are several. I took a sample, and then I also took a sample from my time as an acting judge, because I've acted in the Labour Court, I've acted in the High Court, I've gone back and acted again in the Land Claims Court. But you will see from my curriculum vitae that through my acting in the High Court, I've dealt with a range of issues that have absolutely nothing to do with land reform, and that venture into a whole lot of other areas, both of constitutional law and of non-constitutional law. And I have several reported judgments referred to at the end of my curriculum vitae in the High Court that have nothing to do with land reform. I'm not sure if that answers. I also have a list separately that I can provide of all of the non-land reform constitutional issues that I've had to deal with, both in the Land Claims Court as well as in the High Court in acting. And then as an advocate, I have a wide focus on constitutional law, but I've been involved in a wide range of issues, environmental. I've done a lot of customary law work, and so on.
Thank you. Yes, Commissioner.
Thank you.
Oh, Nyami, yes.
Yeah. Thank you.
Thank you.
Acting DCJ. Morning. What motivated you to accept the nomination as a candidate to the position of a judge in the Constitutional Court?
I have gone through a very unusual route in my career. Normally people go attorney, advocate, judge, and that's it. I've gone an unusual route. I know of no other lawyer who's gone that route, and it's taken me in diverse places. I went from attorney, human rights attorney, to being a land claims court judge, to working in the UN, to being a practicing advocate. And my sense is, firstly, Section 174(5) of the Constitution makes it clear that only 4 of the judges need to be judges at the time that they're appointed. So there's a door that is open to me in the Constitution, people in my position, if there were anyone. And I felt that the experience that I'd had could be of assistance in enriching the adjudication of the Constitutional Court. Both my non-land work, as well as particularly my land work. I think it's going to be a big issue in the years to come.
Thanks. My second question, as a senior counsel, attorney, acting judge, a judge, we have seen it all. What's your view about the current state of the transformation of the judiciary?
My sense as a lawyer, I'm proud of what's been achieved in the transformation of the judiciary in particular. I'm exposed to it because I'm married to a judge in the High Court, and I appear in the High Courts. And my sense is that if I think back on the days of the 1980s, when I was knocking at the doors of the High Court to try and get somebody out of detention, when I was knocking at the doors of the Supreme Court of Appeal after I'd failed in the High Court, and I was faced in the Supreme Court of Appeal with a phalanx of white male judges shaking their heads when we tried to submit that detainees should have been released, or the damages should be paid because of what the police did brutally to somebody. And I see a phalanx of white male men. It was a very depressing experience. If I contrast that experience with what happens now, if I stand up in the middle of the beautiful court and the Constitutional Court, and I see all of the justices sitting in front of me, it's profound. The change, let's be frank, is profound. So my view is a positive one. I think that there has been incredible work done in the transformation of the judiciary. There are some excellent leaders in the courts who lead the courts from the top down. I obviously, because I'm in Gauteng, I have the direct experience of Judge President Mlambo leading the High Court there, who does a fantastic job. So I think that it's been a fantastic achievement.
Thanks,
Thank you.
DCJ.
Thank you. It's going to be Commissioner Club. I think he had his hand. Did you have your hand? Oh, no, I saw you, but I thought he was before. Then it will be. You are fine. You are covered. Okay, it will be Commissioner Dodovu, then Justice Spetze, and then Commissioner Malema. Oh.
Thank you very much.
Yes, okay, all right. Thank you.
DCJ, just my two questions. You acknowledge, firstly, that you are strong on the areas of constitutional law, administrative law, and labor law, and that you have not done criminal law, especially when practicing as a counsel. How will you compensate that as if you are considered to be a judge of the Concord?
I think a lot of people come to the bench in the position that I'm in, where they haven't immediately had a practice in criminal law. But the truth of the matter is that in the early 80s, I did almost exclusively criminal law. That was during the time of the uprisings in the townships, protest uprisings in the townships. And I spent my days doing criminal work, representing people, mostly young people charged with public violence, also some more serious crimes. Our firm was the firm that was appointed in the Yengeni trial. So my early years have steeped me in criminal law. I've run my own criminal cases as an attorney, and it's a bit like riding a bicycle. I don't think that you forget that stuff, even though I've had a long period away from it.
Okay, my second question relates to Section 27 of the Constitution. I can see that you are very strong in that area around healthcare issues. What do you think the current pandemic, COVID-19, what challenges do you think it will impose to our health system, especially in terms of adjudicating issues of vaccination? A lot of people say no, but we all know that is very risky. What is your view on that?
So there's more than one component to your question. I'll try and answer it quickly. It's been a completely novel experience for the courts. I think the courts have responded well. I think in many respects government has responded well, even though they've been subject to so much criticism. It's such a new thing and so difficult. I think that what is needed for the future is a dedicated statute for pandemics. I don't think the pandemic fitted comfortably under any legislation, whether it would have been a state of emergency or even the Disaster Management Act. We need dedicated legislation to provide for it in future. We need legislation that would enable centralized control during a pandemic of both public and private healthcare from a national level to respond. I think the legislation should provide for a dedicated fund that gets built up and that is kept in reserve and grows, so that the economic impact can be dealt with in future if ever we have a similar experience over and over again. To come to the specific issue of vaccine mandates that you refer to, I need to be careful about answering that. I think that issue is going to become before the courts, but I can speak very briefly about the issues that it raises. It raises issues in relation to Section 12.2, the right to bodily integrity. It raises issues in relation to Section 9.3, as well as PEPUDA and the Employment Equity Act, in relation to potential discrimination on the grounds of thought, belief, and opinion. It raises the issue of possible limitations of Section 15, the freedom of thought, religion, belief, conscience, and opinion. And if vaccine mandates are going to be debated, one then has to see, are the limitations of those rights justifiable with reference to Section 36 of the Constitution? There are laws of general application. There's the Mine Health and Safety Act. There's the Occupational Health and Safety Act. Those present real challenges for employers because employers have to provide a safe working environment to employees under those statutes. How do they do it if some people are saying, I'm not going to get vaccinated? The science says vaccinations work, they help. So how does an employer respond? I don't want to express a final view on the issue, but I would be ready for the debate were it to come to court. I know what the issues are, and I know what would influence the final outcome.
Thank you very much. Thank you, DCJ.
Thank you. Justice Betze.
Thank you, Acting Chief Justice.
Before you continue, I'm sorry, let me just announce so that we are all aware. I think we are 10 minutes away from reaching 40 minutes. So I mentioned that so that we are just all aware, but continue.
Thank you, Acting Chief Justice. Good morning, Mr. Dodson. I've got two questions for you. One of or some of the critical attributes of a good judge, especially one who's aspiring to serve on the Constitutional Court, are experience, scholarship, dignity, rationality, forensic skills, humility, a capacity for articulation, diligence, integrity, intolerance for injustice, emotional maturity, courage, objectivity, energy, both physical and emotional, efficiency, wisdom, and the moral ability to distinguish the right from wrong. Do you think that you possess those attributes to a sufficient degree that would make you a good judge?
The short answer is yes, I do, but the moment one says it, one feels as though one is bragging. But I think in sufficient quantities. I'm a human being, and human beings are fallible, but I think that I have those qualities in sufficient quantity to be able to do the job.
Thank you. My second and last question is, of the 7 candidates that will be interviewed by this commission, you are the only one who's not a sitting judge. Wise mindful that that does not in itself disqualify you. What would you say would be compelling factors which, in your view, should tip the scales in your favor?
I think the beauty of Section 174.5 is that it allows this body to look at candidates who've gone a road less traveled, a different route through the profession. And I think that the route that I've followed is one which can really enrich the adjudication of the Constitutional Court. Yes, it involves work at the bar, but I believe that work at the bar is an incredibly important and helpful component of the skill set and experience set that one brings to the court. When I left the land, if I'd stayed at the Land Claims Court and simply gone through the tiers of the courts, bearing in mind how young I was when I started, I would not be as comfortable as of the fact that I'm a good lawyer as I am having gone the route that I've traveled. But I've traveled that route without dropping adjudication. For 7 years after I left the Land Claims Court, I headed up an adjudicative body, an international adjudicative body, with people of the level of Supreme Court judge in former Yugoslavia, a top international arbitrator. I was responsible both for adjudication in that body, as well as, because I was the chairperson, effectively running the commission. from the adjudicative side, managing it, getting a group of lawyers from all over the world to work together as a team and achieve a goal. I've also continued to be involved in the work that is appropriate for adjudication, in the work that I've done over the years on the Independent Regulatory Board for Auditors Disciplinary Committee. I've attached one of the decisions to my documentation. It can be read. It dealt with a constitutional issue. I've also referred in my curriculum vitae to a 472-page decision that I handed down exactly a year ago on the 5th of October last year. In that body, it dealt with a really complex area of the law and of auditing. It involved a bank audit, a charge against bank auditors, canvassed a range of legal issues, a range of accounting issues, a range of commercial issues, a range of regulatory issues. And as I say, that was the 5th of October. It was a year ago. So yes, whilst I've gone to the bar, I've remained involved in adjudication because of the fact that I was a judge, that I was made chair of this disciplinary committee, but also because I was a judge, I do an enormous amount of opinion work. And the rational process one goes through in writing an opinion as an advocate
Chief Justice.
Thank you, Commissioner Malema.
Thank you, DCJ. Advocate, how long should the Constitutional Court take to adjudicate on an agent matter?
The Constitutional Court faces a difficulty in that they make their decisions en banc. All 11 judges have to come to a particular decision. Then it becomes difficult. So it's very difficult to answer. But there are circumstances that the courts also need for lawyers. Sometimes quickly enough, it can become irrelevant or it can become unhelpful. So it depends on the circumstances, it depends on the stance of the judges, but obviously they must look at the facts and they must attempt to respond and provide a judgment that assists the parties and provides a resolution to their dispute as quickly as possible.
You are applying to be a judge of the Constitutional Court, and I ask you a simple question, and then you say something too long. I don't even understand what you are saying. Because this question is the one that is going to guide your conscience when matters appear before you and your colleagues, that we agree that this is an agent matter. And that should, in guiding your conscience, then be able to say, within a particular period of time, we should be able to have resolved this matter if things are normal, to say. So I just want to have an idea, because I'm not a lawyer. And I'm sitting there at home and I see something called an agent matter, and it takes forever to be resolved. All I'm asking is, what will be an ideal situation where a competent constitutional court takes to resolve an agent matter?
All I can do is judge by my own experience at sitting in the Judicial Court in Johannesburg. When I sit in the Judicial Court in Johannesburg, I try and give a judgment there and then. For following my own guideline, if I was in the Constitutional Court. But there are difficulties. That's the best answer that I can give.
Is there anything that needs to be changed to the Constitutional Court?
The one thing that worries me a bit at the moment is turnaround time with with processing of cases. I can think of at least one case that I've got that's been waiting for a long time to get an answer. We filed heads in the case. We were asked to file heads a long time ago. We filed heads. We just don't know what's happened in the case. But that's not a universal experience. Mostly my experience has been good. But I think that case is indicative of a problem. But I think it's difficult for the court. They sit on bank. I think they have a massive load of applications for leave to appeal. I think that's a problem that needs to be addressed. But I don't think it's the fault of anybody. I think systems need to be developed to process those. We had to do the same when I was chairing the commission in Kosovo. We had 30,000 claims. We had to decide them in a short space of time. We had to work out methodologies to process them as quickly as we could.
With your indulgence, DCJ, you can't say it's not a fault of anyone. Because someone must take responsibility. We can't have a situation in this country under this constitution where things are not happening and we say we can't put a fault or a blame on anyone. In a situation where the Constitutional Court, in a case that we are telling us about now as an example, where there is no clarity of what is really happening, who takes responsibility for that at the Constitutional Court level?
Mr. Lima, I don't want to get involved in a blame game. And I'm a person who's never acted on that court. I don't know what the circumstances are that obtained that.
Constitution for, let's say, in the last 3 to 5 years. Thank you.
I spent 5 years as a judge on the Land Claims Court, involved in a wide range of adjudication, and that puts it in a very different light. I was a permanent judge for those 5 years. I wasn't an acting judge. And that's the primary basis for my judicial experience, along with the 7 years that I spent in Kosovo, heading up a commission adjudicating. That too was a permanent appointment. And one can't look simply at the fact that I've done 20 weeks of acting and ignore the fact that I've spent 7 years in the position in Kosovo. I spent 5 years on the Land Claims Court. It comes to 12 years altogether. The research I did do was to look at the amount of time that the current judges on the Constitutional Court spent as judges, permanent judges, before getting appointed to the Constitutional Court. And I think the average I got to was about 12.5 or 13, somewhere around there. I've got a similar period involved directly in in adjudication on a consistent basis, taking into account the Land Claims Court and the 7 years I spent on that commission. So they're very much comparable. Yes, I've only acted for 20 weeks. It's not too bad. It's given me a wide range of experience, and in a short period of time that I've acted on the High Court, I've several reported judgments. And the short answer is no, I haven't done the research that you referred to in your second question.
Thank you.
Thank you.
Sorry, Acting Chief Justice, if I can just perhaps mention one more thing.
Sorry?
If I can just mention one more thing, if you don't mind,
Yes,
in
yes.
response to the last question.
Yeah.
Just to point out that nowhere in the Constitution is it a requirement that one has acted as a judge before one is appointed to the Constitutional Court.
Thank you. There was also, I think there was another commissioner who wanted to ask questions from those who are virtual. Oh, Commissioner Breitenbach.
Thank you, Acting Chief Justice, and good morning to everybody. Good morning, Mr. Dodson. You have had a role as the chair of the IRBA's disciplinary committee for some time, and that gave you obviously the opportunity to deal with the complex commercial matters. Do you believe that this experience would be beneficial to the Constitutional Court bench going forward, especially in view of the sort of near future?
Yes, I certainly believe it would be of assistance, and that's part of the reason why I say I come a different route, and I think that experience will potentially be invaluable on the Constitutional Court. There are going to be issues that come before the courts as there are big company failures and so on in the future. Those issues are going to reach the Constitutional Court because of Section 167(3)B's broadened jurisdiction.
Thank you, Acting Chief Justice. I'm done.
Thank you. Commissioner Nokesi, before you ask, I just want to say, in the light of time, if there are any colleagues who want to voluntarily say they are covered, that would be great. Or those who want to say, I'll ask one question instead of two,
Yeah.
that would be great. Okay.
No,
You'll ask one. Thank you.
In fact,
Commissioner
in fact, I'm also doing exactly that
Okay,
because
thank you.
Commissioner Singh has
Thank you.
helped me. But there's one thing that troubles me. You say, admittedly, you never acted in the Constitutional Court. But when Commissioner Malema asked you about urgent applications and judgments, you give a detailed explanation, the difficulties that the judges of the Constitutional Court face before they take a chance. Where do you get that? That's my only trouble with your answers.
One picks up information about how adjudication takes place, but one can simply infer it from the judgments. Look at one of the judgments where there are 3 different sets of opinion, and you can see where the difficulties lie. It's a matter of logical inference.
Thank you, Commissioner Nokesi. Then Commissioner Mtolo Shepu.
Thank you, Acting Chief Justice. Good morning, Advocate Dodson.
Good morning, Commissioner.
I heard you earlier saying, and I think it was in response to Commissioner Dodovo's question regarding the transformation of...
Maybe you might raise your voice, speak up a bit, or bring your mic closer.
I'm saying, I heard you earlier saying that the change in the Constitutional Court is profound, and this transformation in the Constitutional Court. I'm quite worried in the sense that you seem to see transformation as those judges who are sitting there, not people who are representing the claimants or the applicants in the Constitutional Court. Do you still believe that there is change? Because for me, the judiciary includes people who are representing people in the Constitutional Court.
I understood the earlier question to relate purely to the judges, to the judiciary, not to the profession. The profession's a different kettle of fish. The profession's got a long way to go to be properly transformed. That I acknowledge immediately and without hesitation, and I agree with you. There's an enormous amount that has to be done.
Just a follow-up, what do you think the profession should be doing to enable people to be represented by other races in the Constitutional Court? The difficulties are many.
There is a problem in relation to briefing patterns. There's a problem in relation to disadvantage from the earliest times in relation to the different circumstances in which poor people have to study compared to privileged or wealthy people or people's children who have to study. There are problems in terms of accessing the profession. They are predominantly people, in fact, usually if I think of the groups that come before us, there are usually groups of about 8 pupils. Invariably, I think only one is usually a white person. The rest are historically disadvantaged individuals. I think those programs are those advocacy training programs are of great assistance. I see, as the years go by, I see fantastic talent on display in those training programs. So I think people will come through, but people have to work hard. The bar has to work hard. The attorney's profession has to work hard to create opportunities for people. We run a junior fund in the Victorian Kleinge group. The bar also runs a junior fund where we put money into a pot every month so that if one of our young members is struggling, we can bring them into a matter even though the attorney hasn't briefed them. And then there's a huge obligation on us as senior practitioners to bring in people who come from disadvantaged backgrounds. And I think that it's taking time, but I think it is starting to show some benefits. It's not nearly fast enough. I think you in your position are well positioned to push us in your position on the Legal Practice Council to push us harder, make sure that we do more, make sure that when people are standing up in the Constitutional Court, we see a better picture from that way, from the judges looking down.
You're covered. Thank you. And then Commissioner Chapter.
Thank you, CJ. As I said, I will ask one question because the other question was asked by Commissioner Malema. Thank you. Good morning, Advocate Dodson. Could I just ask you if you could just give examples of some of the judgments, particularly in recent times, where you would have dealt with matters in relation to Section 39(3) of the Constitution, which requires that when courts are interpreting any legislation, and they must. And when developing common law and customary law, they must promote the spirit, purport, and object of the Bill of Rights. Do you have any cases that you have, and if so, if you could just deal with one or two of those? Thanks.
Okay, 39(2). I think you meant. Yes. The cases that immediately come to mind are. The airport company case, which I've attached to my documentation. And there I applied it in the context of when do you read a tacit term into a contract. And what I said is that the parties, in thinking about whether a lease would be extended during a tender process at the end of the lease, would contemplate that a lawful process would follow in order to choose a replacement tenderer for in that case it was for rented space in the airport. The other example that comes to mind is in relation to the Kransport judgment. In relation to the Kransport judgment, I had to deal with a difficult situation where the community had to prove that they had a right in land, but it was under apartheid where the legislation did everything to deny people having rights in land. And so what I did is I adopted that particular provision to arrive at a situation where I interpreted quasi-possession in their form of occupation of the land on a mission station as being a sufficient basis to qualify under Section 1 of the Restitution Act in interpreting that particular provision as a right in land that entitled them ultimately to have the land restored to them in full ownership.
Thank you, CJ. Thank you, Advocate Dodson.
Thank you. And then it will be Commissioner Madonsela.
Thank you, Acting Chief Justice, and good morning, Advocate Dodson.
Good morning, Commissioner / Advocate Madonsela SC.
Thank you. I've generally been covered by Deputy President Tsepe and Mr. Dodovu, Commissioner Dodovu. But I will ask just one question, just on that topic, on the topics that they raised. Are you really averse to making yourself available for the High Court position as a judge?
The difficulty for me with a High Court position is that essentially it takes me back to the position I was in 1995. The Land Claims Court is a court of equal status to the High Court, and it essentially means I've got to start again where I left off some 26 years ago. And, you know, I've got a limited span of my working life left. I need to choose carefully what I do with the years that are still allotted to me. And the short answer is I don't see that as part of my plan for the period that's allotted, to the remaining period of my working life that's allotted to me.
Using the language of jurisdiction, which we use as advocates, I've always thought that you go to the ways to go to the Constitutional Court is via confirmatory jurisdiction of the court or appellate jurisdiction of the court. It seems to me that you want to go by direct access. I thought that we required exceptional circumstances for direct access in the Constitutional Court.
Well, Mr. Madonsela, in response to that, you and I are lawyers and senior counsel. Let's have a look at Section 174.5. Section 174.5 specifically envisages people who have had no judicial experience at all going directly to the Constitutional Court. And that is a live provision of the Constitution. It hasn't fossilized. There's a well-established principle that is repeated over and over again in the judgments. The Constitution is a living document, and meaning must be given to every single one of its provisions. 174.5 is one of those provisions, and this Commission cannot pretend that that section doesn't exist. Parliament conducted a thorough review of Chapter 8 of the Constitution when they expanded the jurisdiction of the Constitutional Court. If you look at those provisions, let's have a quick look at them. They amended virtually every single surrounding provision around 174. So 167, 168, 169, 170, 171. I think all of those were amended. So
I'm very much aware of
but I'm trying to make a point. The point I'm trying to make is this. If Parliament wanted to get rid of Section 174.5 and to say you can't come to the Constitutional Court without having followed a route through the judiciary, they had the full opportunity to change it. When they did that review, Parliament chose not to change it, and with respect, the Commission has to acknowledge that. They have to give meaning to 174.5. And it allows somebody with my track record to come to the Constitutional Court. And this Commission can't turn around and adopt a different interpretation that's not permissible in the Constitution. It can't overrule the Constitution. Every provision must be given a meaning and must be respected. It's on the statute book. It opens the door for me. The Commission can't close the door to me. The Commission can't grudgingly hold the door a tiny bit open to me. The Commission must hold the door fully open to me because the Constitution tells it to do so with respect.
Yeah, well, I don't want a debate about it. Can I just throw you just one question? You mentioned in response to Commissioner Tsepe the judgment in AXA versus the exclusive books. Your interpretation and the importation of the tacit term went on appeal in the SCA. My recollection is that the SCA did not affirm your importation of the tacit term, but decided the case in your favor on different topic and expressly disavowed the endorsement of the tacit term that you sought to impose in the AXA judgment. Is that correct?
No, I don't think the last bit is correct. They did decide it on a different basis, and as I read it, they didn't need to go into the other issue. I don't think they disavowed it.
Thank you.
Thank you. The next one will be Commissioner Mpofu, and after that it will be Commissioner Lucas, and I propose that we stop there. But before I allow Commissioner Mpofu, may I clarify this, Mr. Dodson? The answer that you have just given to Commissioner Madonsela, is my understanding correct that what you are saying is that the experience that you have acquired during the period when you were not a judge needs to be taken into account. If somebody else has been a judge during that time and has been gaining judicial experience, all of these must be taken into account and weighed, and then a decision can be taken as to how much weight should be attached to the judicial experience over that period, and how much weight should be attached to the non-judicial experience, but nevertheless relevant experience. Is that what you are saying?
I wish I could have said it as well and as briefly as you, Acting Chief Justice.
Okay, right. Commissioner Mpofu.
Thank you. Good morning, Alan.
Good morning, how are you?
I'm well, thanks. Yeah. Right. Well, I was going to ask you one question, but I'm tempted to ask you 1.5 because I also, with Commissioner Tsepe, double up as the communications person for the Commission. And there is this notion out there that the criteria are not clear. And I would say maybe they're not clear enough, but I think sometimes it gets exaggerated. So I want to take the opportunity, because you have cited section 174.5, that the people out there might not know what it says. It says, at all times, at least 4 members of the Constitutional Court must be persons who were judges at the time they were appointed to the Constitutional Court. That's the one, yes. Now, I just want to assure you that we are fully aware of that section. If we were not, you would not have been shortlisted. So we're very aware of that. But the issue is, for me, the question I wanted to ask you really relates more to section 174.2, which says that the need for the judiciary to reflect broadly the racial and gender composition of South Africa must be considered when judicial officers are appointed. And just to assure you again, I'm the first one to say that that section is limited. I've even proposed a constitutional amendment to expand it. But the issue really is this. You have 3 ostensible disadvantages as you sit there, and I say ostensible advisedly. The first one is you have addressed, so we won't go into it. That is the fact that you have not acted in the Constitutional Court. You've addressed that. The second one was asked by Deputy President Petse regarding the fact that you are not a sitting judge, or I think it was Commissioner Nyambi. You've addressed that, and that goes to the 1745. But the third ostensible disadvantage, and I say ostensible because these are not disqualifiers, but they are, is the fact that you are a white male, and nobody seems to be talking about that. That's the elephant in the room. So, in the same light as Deputy President Petse, when we do our deliberations, what must we, how are you going to convince us to overcome that issue? I just want to give you that opportunity briefly.
I appreciate that, and I'm glad that you raised it. There's not much I can do about the fact that I'm white, and there's not much that I can do about the fact that I'm male. and I don't want to sound soppy, but to use words which are not mine, I am an African. I've lived in 3 different countries in Africa, but South Africa is my home. Every cell and fiber of my body is made from the African soil. I haven't relied on my whiteness to take advantage. From the moment I stepped into a law firm as an article clerk, I was out defending people who were being hammered by the police. I got into a bit of trouble in my first couple of months at the law firm because I wasn't earning any money. I was just going off and representing people. I wasn't charging anybody a fee. And one of the partners called me in and said, look, we like the work that you're doing, but at the end of the day, we've got to pay your salary and you need to earn some money. I'm taking you to the dependents conference to go and talk about how you can actually at least charge a small fee for the work that you're doing. I was in a commercial firm. I could easily have followed a path in a commercial firm that was rewarding financially and pretended that the problems in South Africa didn't exist. But I didn't use my whiteness to do that. Before then at university, I fought it. So to the extent that I have a white skin, I haven't taken advantage of it. And I've done the best to use the privileges that still come with it. I don't deny that there haven't been privileges that have attached to my white skin, but I've tried to use the resources and the privileges that I've had educationally and so on for the betterment of the country and to represent the disadvantaged in South Africa.
Thank you, Mr. Chair.
Thank you, Commissioner Bofu. Commissioner Lucas.
Thank you very much, Deputy Chief Justice. Good morning, Advocate Dodson. I really I was hoping that someone will ask the question that they know I will ask, exactly because of the kind of...
You might wish to raise your voice a bit or bring the
Do
mic
I speak
closer.
like a tokolosh? No, I was really sincerely hoping that someone will ask you this question because of what I actually purport to represent. I will usually ask this question, and the issue is that in our consultation with women, we find that there is no just dispensation, particularly with regards to land ownership. As someone with your background and someone that is actually aspiring to become a constitutional court justice, what will you say need to be done to make sure that we see the just dispensation that we are speaking about? And that will be my only question. Thank you.
Thank you. Thank you, Commissioner.
So, as I understand your question, it relates to the oppression that women face in relation to particularly the land.
Particularly land ownership.
Land ownership. And what will I do about that?
What will you see as a just dispensation, generally?
Well, maybe let me ask this. If I understood the question correctly, she is asking what you think should be done to make sure there is justice for women in regard to land ownership. Did I get it right?
And particularly in front of the courts.
Or particularly in front of the courts.
So I have sympathy for your position because obviously in my work as a doing land related work, I've seen the difficult position that are faced by women, even though they are, in fact, in the rural areas, women are the majority by a significant number. I think a lot of the difficulty comes perhaps from the patriarchal component of customary law and the way that land is administered in rural areas. I think it is a tragedy that after the Communal Land Rights Act was declared to be unconstitutional in the Constitutional Court, it's a case that I was involved in, that we haven't yet, after all of these years, I think it's about 15 years now, got a replacement act. And it's through a replacement act for the Communal Land Rights Act that I see as the best opportunity for trying to improve the position of women in relation to land ownership. Part of the problem is also that there is no legislation, still to this day, that properly addresses the question of land redistribution. There's legislation to deal with security of tenure, there's legislation to deal with restitution, but not to deal with redistribution. And if one looks at the role that women play in rural areas, particularly in relation to farming, it's massive. Women shouldn't just be equal in land areas, they should probably predominate in land areas, in rural areas, in relation to land ownership. And so I see a crying need for a dedicated law dealing with land redistribution. And when they set criteria, because what that law is going to have to do, it's going to have to assess what the position is with land in South Africa. It's going to have to assess what the demand is for land in South Africa. It's going to have a ranking process for the allocation of redistributed land to people. And it's there that I think the position of women should be addressed. I think there should be a point system when it comes to the allocation of land for redistribution. And I think that point system has to be weighted in favor of women. They're the ones who've actually done probably most of the farming in the rural areas. They're the ones who probably come with the best chance of using the land well if it's redistributed to them. And I think that it's in that allocation process and that point system that you can address the problem that women have faced. To some extent, the problem has also been dealt with by the judgment that I was involved in, involving the person who seeks to be recognized as the Queen of Venda. We got the court to declare that, to recognize that the rule of male primogeniture in relation to succession to customary law positions is unconstitutional. And I think that is going to take time, but I think that's also going to have a massive impact and will come down to issues of land ownership because it's the traditional leaders who administer and adjudicate disputes in relation to land. I hope that answers your question.
Thank you. Thank you, Advocate.
I'm sorry it was long.
Thank you, Commissioner. I think that we are done with Mr. Dodson. Thank you very much, Mr. Dodson. We appreciate that you made yourself available. Thank you very much. You are released.
Thank you, Acting Chief Justice.
Thank you.
Thank you, Commissioners.
Thank you.
Thank you.